Good, good morning, everyone. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels. My apologies for my appearance today. Again, just didn't feel like makeup. Every once in a while, you get those weeks where you kind of just want to give the makeup a rest, let your face restore itself, not feel the need to be the doll. But that's neither here nor there. We're going back to that wonderfully messed up world of the JRC. We are rounding up the countersuit documents for the Judge Rotenberg Education Center Incorporated versus the U.S. Food and Drug Administration. Bleh, can't talk. Already got my second dose of caffeine waiting for me. Quite telling, isn't it? Incorporated. That just says it all. But, anyways, folks, just a few quick little tad bits before we go ahead and move on this morning. As always, folks, the document we are reading you will find right underneath the description box, right along with the very first video I did on this subject, which not only goes over all the things we know thus far about the case, at least up to the point of 2012, but it also includes at the very end of the video why we are covering the JRC again. Namely, that they were able to have the ban on the GED device not enforced due to COVID, and they are in the appeals process against the ban from the FDA, which right now means that the students of the Judge Rotenberg Center are still having electrodes attached to their arms, their torso, the backs of their legs, in some cases, even more sensitive areas. Students are still being treated with sleep deprivation and food deprivation. You know how it goes. Also included is the Change.org petition to shut down the Judge Rotenberg Center. If you haven't already signed it, please do. Okay, we are moving on to part 3 today. Now, apologies in advance if I mangle any legal jargon or trip over my words. Also, when we talk about the JRC, as before mentioned, we are talking about vivid descriptions and actual footage of people with disabilities being tortured. So if you have young ones present when you watch these videos, please be sure to wear your headphones. Whew, okay. I said all of that without taking a breath. Discussion. The parties' cross motions for summary judgment raise 4 categories of disagreements. Whether the defendants have impersonally withheld non-responsive information contained in otherwise responsive records, whether the defendants have properly invoked the deliberative process privilege under FOIA Exemption 5, whether the defendants have properly invoked Exemption 6 to withhold medical and similar records to protect against any clearly unwarranted invasion of personal privacy, and whether the defendants have produced all reasonably segregable, non-exempt information. These issues are considered seriatim. So this is where they question whether they have the right to use attorney-client privilege and HIPAA law. Wow, the balls on these people. It's the JRC for you. Everything just so we can torture people and call it medicine, right? The plaintiffs have also challenged the defendant's failure to produce roughly 150 email attachments to records from the New England District Office. Excuse me. Which attachments originated with FDA's CDRH, First New England Do Declare. Those attachments have been referred to CDRH to include in a future production. The plaintiffs contend that referral to CDRH is no substitute for releasing the attachment because the New England District Attorney's Office remains responsible for producing these attachments. Yet agencies that receive FOIA requests and discover responsive documents that were created by another agency may forward or refer to those requests to the agency that originated the document. Referral is proper when doing so does not constitute an improper withholding of agency records, as would be true if the referral's net effect to impair the request's ability to obtain the records or significantly increase the amount of time he must wait to obtain them. Can we get more words sounding? We want records. We want protected HIPAA information. We want you to violate the law and do what we want so we can continue to torture the kids for their own good. Here, the CDRH and any other HHS component to which a referral has been made are subject to a separate production schedule. Allowing CDRH to complete production consistent with the prior scheduling order does not impair the plaintiff's access to the requested email attachments. Accordingly, the plaintiff's request that these email attachments be produced outside court-ordered schedule applicable to CDRH is denied. Withholding of a non-responsive information. The D.C. Circuit recently clarified that an agency in receipt of a FOIA request need not produce non-responsive records, but must nonetheless release non-responsive information within a responsive record. The defendants agreed that the initial production, which redacted non-responsive information with responsive records, violated this rule. To correct the problem, the defendants re-reviewed their redactions of non-responsive material and have unredacted and released non-exempt material within responsive records that was originally redacted on non-responsive grounds. Yet the defendants continue to withhold some non-responsive information because they deem that information so distinct in the document with the responsive material as to constitute a separate record. The defendants shift now claiming to have withheld only non-responsive records puts a spotlight on a variation of question of what constitutes an agency record under FOIA that has become particularly relevant since AILA. When must information be grouped into a single agency record, and then can information be separated into multiple agency records? Although FOIA includes a definition section, that section provides no definition of the term record, explaining that although FOIA does not define agency records, the term has been limited to include only those documents that an agency both creates and/or obtains and controls. At the same time, the FOIA request was made, internal quotations and citations omitted, altercation and emphasis in original. In practice, agencies define a record when they undertake the process of identifying records that are responsive to a request. Oh my God. I hope that I may be understanding this incorrectly, but are they truly saying that the FDA does not have the right to deny them HIPAA-protected information because they don't get to define what's HIPAA information or not? If it's medical information is protected by HIPAA. Period. Seriously? Since defining the universe of responsive records is the first step an agency should take in response to the FOIA request, AILA, agencies have the flexibility to define record in a range of possible ways, but some benchmarks inform that analysis. DOJ guidance, which has been updated in response to AILA, instructs agencies to use the definition of record found in the Privacy Act to guide their decisions as to what is a record for purposes of the FOIA. Thus, each item, collection, or grouping of information on the topic of the request can be considered a distinct record. Department of Justice OIP guidance defining a record under FOIA. Generally, agencies should not define records on less than a page-by-page basis. Department of Justice OIP guidance determining the scope of an FOIA request. FOI update, volume, 16, number 3. Here, if the defendants have committed a consistent understanding of when information should be treated as a single agency record or separated into multiple agency records, why is this relevant? That understanding could have prompted focused judicial review. Yet the defendant's withholding of non-responsive information in this case stutters a more fundamental problem. Midway through litigation, the defendants reclassified collections of information that had been treated as one agency record as multiple agency records. Why does it matter as long as you get the information? What the hell? As the D.C. Circuit has said about an agency's determination of whether a document meets FOIA's definition of agency record, courts must be careful to ensure that the term agency records not be manipulated to avoid the basic structure of the FOIA. Records are presumptively disclosable until the government can show that one of the enumerated exemptions apply. Although the question here is not whether information qualifies as an agency record in the first place, but rather about one record ends and another begins, the admonition against record manipulation is no less applicable. Allowing the defendants to redefine the contours of a given record midway through litigation would invert the ordinary process of responding to an FOIA request, in which the first step is identifying the responsive records. AILA, just because the agency realized that without the change, certain information would be subject to disclosure. That is precisely the sort of manipulation that undermines the purpose of the FOIA. Really? You're claiming you're manipulating it. You're not letting all the records out. And these kids deserve to be tortured. You don't understand. God. Oh my God. That the defendants have altered their conception of what constitutes a single record is evident from comparison of the defendant's second Vaughan Index and third Vaughan Index. Recall that the FOIA requires agencies to account for records only if they are responsive to a request. The statute thus sets forward the broad outlines of a process for agencies to follow when responding to FOIA requests. First, identify responsive records. Agencies account for responsive records either by disclosing the record to the requester or claiming and justifying a statutory exemption. Thus, once an agency identifies a record it deems responsive to an FOIA request, the statute compels disclosure of the responsive record as a unit, except for insofar as the agency may redact information falling with statutory exemption. Although defendants now claim that multiple entries on the third Vaughan Index account for wholly independent but unresponsive records, those records' inclusion in the indices signals that the defendants did not initially review the entries as describing standalone records. If that was the agency's position all along, those records would not have been included in the indices. I'm sorry, in regards to these documents, folks, I swear to God I'm watching paint dry. I swear this is a stall tactic from the JRC. Trying to buy themselves time, what do they think they're going to do? It's a federal agency. They can't freaking outspend them. They're not going to drain them dry of resources to where they can no longer fight. Like, what is even the point? Other than wasting the courts and everybody else's time over arguing semantics about how documents are submitted. Ugh. For the example, the third Vaughan Index entry for an email attachment, Bates stamped JRC OES Supplemental 1 001770 describes the email attachment as its own record. See third index at 356-57. I swear to God, if this is the basis of their countersuit and how they're appealing, God help us all. By contrast, in the earlier second Vaughan Index, the agency described the same document as non-responsive, but included in this production only because it is an attachment to an email that contains another attachment that includes unresponsive material. Second index at 352-53. The second Vaughan index reveals that the defendants viewed the email attachment as a piece of single record that includes the parent email and additional attachment. Otherwise, the record could not have been included in the index at all. Examples of a similar shift litter the indices. Blah, blah, blah. I'm not reading all that. Oh my God, they keep going on. Okay. The defendants of reclassifications are even more troubling because many were done to split emails and their attachments into multiple records. Why does this matter? While emails and their attachments are not per se a single record, at minimum, attachments should be reasonably considered part and parcel of the email by which they were sent. When the email makes explicit reference or includes decision discussion of missing attachments. Even without a per se rule that an email and its attachment must be treated as a single record, the attachments to already produced emails manifestly part of communications between the GSA and PTT, absent any explanation why not belong together. Oh my God, kill me. Attachments should be reasonably considered part and parcel of the email by which they were sent if the emails make explicit reference to or include a discussion of attachments. Blah. Rejecting agency's separation of emails and attachment because the attachments can only be fully understood and evaluated when read in context of the emails to which they were attached. That is why... God, I'm getting so... That is the way they were sent and the way they were received. It is also the way in which they should be produced. Who cares how they should be produced? If you get your information, why does any of this matter? More than ambiguous email practices suggest that agency will struggle to justify separating an email from its attachments into multiple records. Of course, from time to time, emails are sent with the wrong attachment, but ordinary course an attachment is included with the email because it relates to the body of the email. Though not per se rule, ordinary practice leaves very little wiggle room in generally requiring an email with attachments to be kept together as a single record. Here, however, the defendants need not be given the chance to explain why some emails and attachments should be considered as distinct records because reclassifying records midway through litigation is improper. According to the defendants, must release all their records listed on the third Vaughan Index as being withheld for non-responsiveness that are also subject to the FOIA statutory explanation. Oh my God, so through all that word salad that kind of made me want to gouge my eyes out while reading it, essentially, remember when I told you they were trying to say that the FDA was withholding records? Yeah. Basically, through all this jargon, the only thing that this is telling me is that the JRC was trying to use this as their example of the FDA withholding records from public scrutiny and from them. It appears that is not the case at all. The JRC is showing here through their legal jargon what actually happened was the FDA did send out that information. It was just not done in the way that they would like. Please, someone, in the name of God, tell me how this is grounds to try to overthrow a ban. Ugh. I'm definitely gonna need caffeine after that. Holy crap. Okay, folks, I'm gonna go ahead and end it on this note, and don't worry. I'm not even gonna attempt to do another video after that. I have to, reconstruct the pieces of my brain that just blew apart. All right. So we don't get very many views on this channel. The few that we do get do tend to get removed from time to time. So folks, please don't forget to hit that like button, hit subscribe. Don't forget to hit the comments. I do apologize for basically what I just read, which is pretty much the equivalent of watching paint dry on the wall. But I do appreciate you listening through it all. Basically, in a nutshell, if you were lucky enough to scroll past all of that and just hear the end, it's basically the JRC trying to use semantics in regards to how documents were produced during the FDA panel in order to get a ban on a device that causes human suffering overturned. We do appreciate your time this morning, and as always, folks, we here at Spilling Tea hope you have a good one. Bye-bye.